Good afternoon, everyone. Welcome to the 7th session of the two-day national seminar, Reflections on Constitutional Morality in India. So, the current session is on the topic Constitutional Morality and Criticism of the Constitution. So, to speak on this, we have Dr. Real. He's an associate professor with the Department of Political Science at the Hyderabad Central University. He is also an alumnus of our department. His areas of specialization include political theory, Indian political process, politics of globalization, society and politics in Kerala. He has authored numerous works related to these areas too. And also to chair this session, let's welcome Dr. Bismi Gopalakrishnan, who is a professor at the School of Indian Legal Thought, MG University. So welcome both of you. And now over to Dr. Bismi Gopalakrishnan.
Most respected Professor and Head of Department of Politics, University of Kerala, and all my colleagues at Department of Political Science, University of Kerala. You can see Josuti sir and my dear Dr. Arun, and all the research scholars and students who are attending this two-day national webinar on a very important topic, that is constitutional morality. Thank you, Arun, for having given me this opportunity so that I can listen to the lecture, especially a critique of constitution from the constitutional morality perspective. Now, basically, constitutional morality, it has gained popularity in Indian jurisprudence. And obviously, because of a lot of landmark decisions or judgments passed by Indian courts. And actually, it was enunciated by the judiciary as a tool to ensure that individuals' rights are not being taken away from him on the basis of societal morality. But this constitutional morality is being criticized on various grounds. And one of the greatest critique that I've read is K.K. Venugopal himself, who stated that the use of constitutional morality is very, very dangerous. And he was also airing the view that it will die on its own. So to what extent this particular constitutional morality can be accommodated within the Indian jurisprudential terrain, and whether this moral reading of constitution is really needed, and whether the moral reading of the constitution encroaches upon the legislature's authority to make laws. So a lot of questions are there. So let us listen to the resource person, Dr. Biju sir from Hyderabad Central University. So over to you, sir. We are eagerly waiting for your expert opinion on this particular area. Thank you, sir.
Thank you, Professor Bismi Gopalakrishnan, Arun, and the department as a whole, and also the students and other friends. Let me look at this issue from my own understanding of the topic, plus what I heard from the previous lectures in this seminar, without missing anyone, fortunately. So, here my attempt is first to look at two concepts. Two are interrelated concepts, and then let me look at how can we understand constitutional morality, and what are the issues that the constitutional morality is facing in India. First concept that most of the political science students and legal luminaries may be familiar with is the term like constitutionalism. As I understand this term, this is actually more applicable to the limited government concept, means the constitution and its binding on the state. But when we move from that concept, and also a lot of standard definitions are available in many of the open dictionaries, which is accessible to everyone. Stanford Dictionary or Encyclopedia Britannica, all of them will define easily with some kind of consensus about what is constitutionalism. But when we look at the topic, which actually the leading thing of the webinar is actually constitutional morality. I think in my search, I didn't find out any universally acceptable definition of what is constitutional morality at all. One. Second, that provides us an opportunity for engaging with the concept of constitutional morality from different vantage points. That is why this is a term, this is a vessel word, not like constitutionalism. A vessel word means if you use the word or a concept as a vessel word, anyway, whatever is filling in will give it the shape. It doesn't have any definite shape at all. So constitutional morality, then again, if we go through the academic literature on this constitutional morality, again, we will find out one of the interesting article written by Prabhat Bhanu Mehta, the expert in constitution, mainly a liberal academician, who has also who has written in 2018 an article on constitutional morality in seminar. And that is one of the finest piece of article we were getting. And also yesterday I heard many other scholars were also speaking about this constitutional morality, mostly in line with what Prabhat Bhanu Mehta is bringing this concept. Mainly he is again making a reference to Ambedkar. Then I was also surprised to see whether other than Ambedkar, nobody else was there to make a reference to this concept. Ambedkar used the concept. That is the way in which we can understand it. Whether he gave a meaning to that, it's true. He gave some meaning for that. And as Neeraj Chandok was yesterday, Professor Neeraj Chandok was yesterday saying, he was also speaking, like many other leaders, who were part of the freedom agitation, moving with agitation. And once they understand that there is a transfer of power, they were speaking about constitutional morality in terms of restraint, not on state alone, but also among the citizens. That is why constitutional morality is on the one way, there is a tendency among the liberal intelligentsia in India to understand it as an exaltation of freedom. But it is not the way in which constitutional morality is being understood. This is actually a kind of a rule-obedient society. Means, Prabhat Bhanu Mehta, again, if we look into his point of view, we can also see that constitutional morality has two aspects. Generally, as I understand constitutional morality. One is related to principles. Second is related to code of conduct. This code of conduct is actually more important for Prabhat Bhanu Mehta to look at, and also not for him, but for many liberals. The code of conduct in a very liberal mode, with opposition respect, listening to others, saying certain things firmly, but accepting the point of others. Even if we accept the others, we will not move from our position. This type of a liberal code of conduct is generally understood as constitutional morality. And these are the two aspects. One is principle, and second one is about the liberal code of conduct. And then we will have to look at the way in which we are now struggling to find out a meaning for constitutional morality. And we are also trying to search for a constitutional morality from the Constitution, either in its formative stage or in its later evolution. And there are several other things also we will have to take into consideration. Normally, when we speak about in an ordinary understanding or a common understanding of constitutional morality, when we speak about it, we generally tend to look at the moral consciousness of a polity. That has to be understood as a result of interaction between two other types of consciousness. So I would like to describe before you three types of consciousness which are actually coming to help us to understand what is constitutional morality. One is moral consciousness of a polity, which shall be produced on the basis of an interaction between a legal consciousness and a social consciousness. This moral consciousness of polity can be otherwise interpreted as a popular common sense. So constitutional morality, when we understand, sometimes there is a problem in giving overdue emphasis on the legal consciousness over the social consciousness. This is the way in which most of the speakers were interpreting Ambedkar yesterday, that he was always talking about constitutional morality as a superior wisdom to come from a legal consciousness to fight the social consciousness. That social consciousness is also not very natural, because the social consciousness is also the dominant consciousness of the dominant group. Mainly for Ambedkar, it was Brahmanical castes in India, or Brahmanical groups in India, or the groups which were subdued by the values of Brahmanism. But here what we are missing is a kind of a single way assertion of legal consciousness over social consciousness. Is not actually giving us an idea of, is not able to find out actually where the social where the constitutional morality is lying. Constitutional morality, Ambedkar was talking about constitutional morality in 1949, the first time, and in the Constituent Assembly when presenting the draft constitution and all. And then he was talking about the necessity of the constitutional morality in terms of pure legal sense, legal consciousness. Ambedkar was right. There is no doubt. At that time, anyway, better than the constitutional morality, there was nothing in India to show as reliable for building a democracy or a future constitutional state or decide in the code of conduct, etc. But the issue is that now we are talking about this constitutional morality, which otherwise I would like to call it as a kind of its relation with popular common sense after 75 years. Nowadays, we cannot go to legal consciousness to find out a pure legal consciousness to verify what type of a morality, what type of a social consciousness, and what type of a popular common sense is available for us today. So this is one of the problem in understanding constitutional morality. Constitutional morality in a legal consciousness way, if we say about it, it was there at a time. And later on, we see an interaction between the social consciousness and legal consciousness to produce a kind of a popular common sense. Without understanding the popular common sense of India, or without an attempt to understand the popular common sense of India, this is difficult to find out the relevance and irrelevance and renewed significance or insignificance of this concept like constitutional morality. So constitutional morality has to be understood in terms of an interaction between legal consciousness and the social consciousness. And what did it produce? Normally, there is a popular common sense is being produced. So for looking at it, actually, we cannot take, anyway, I cannot take constitutional morality as a thing to bring out, to test politics in India. But I will have to go in other way around, because I will have to take into consideration the politics of India to understand what is the constitutional morality. That would be a more realistic understanding of constitutional morality. Otherwise, we will be trapped in some kind of public school book instructions to students, like students' manual, go this way, because I told you already that constitutional morality is one way about a moral code of conduct. This moral code of conduct anyway is available not only, I don't want to refer to constitution to look at the moral code of conduct. I can look at various other religious manuals, church instructions, school instructions, college hostel instructions, etc. But the problem here is that because more than a code of conduct and more than certain principles which loosely stated, we will have to look at actually the reflection of this constitutional morality in the mind of the people. Otherwise, anyway, we'll miss the entire picture of what actually is constitutional morality. So let me begin this exercise of presenting briefly on what I want to say on this constitutional morality by looking at 4 or 5 stages of the history of Indian Constitution. First, anyway, would come obviously the formative stage of Indian Constitution. What was the constitutional morality then? Then I will divide the Indian politics into the history of Indian politics into 2-3 phases, and we'll look at what happens to this constitutional morality. Even though the judges were pronouncing it more recently, there is no room to believe that even before the clear pronouncement of this constitutional or reference to constitutional morality in certain verdicts, there is nothing like constitutional morality. There was always something like constitutional morality even before and after making the constitution in India. We will have to look at it in a long historical perspective to bring out what actually it is and what are the problems it faces. What I am talking about is first about the making of the constitution. In the previous lecture, anyway, Professor Prabhash was talking in detail about the formative stages of constitution. So what is my task is to add some points and also to look at it slightly from a different perspective than what other speakers were doing. First, what we will, first thing that strike my mind is there is a problem in bringing a kind of a legal consciousness, the constitutional morality as a guideline for the people of India from the beginning itself. Problem is with the composition of the assembly. Composition of the assembly, we know well that it was on the basis of a restricted franchise. 28% of the adult population only voted for electing the members of the assembly indirectly through provincial legislatures, and many of others were nominated. So there was no direct election. Yeah, I am not telling about there was a necessity of direct election then. But what I was telling, because this restricted franchise actually elected the assembly, and the assembly was reflecting some kind of a constitutional morality, it lost its appeal. If you say that there was a constitutional morality from the beginning, it lost its quantitative appeal from the beginning. And later what it happens is the assembly itself is opening the field of democracy for an adult franchise. So the translation of a constitutional morality of a restricted franchise to a morality of whatever, political morality or constitutional morality of the larger, is actually a big task. That was one of the basic problem that India was facing when we were talking about constitutional morality as explained as the wisdom of the Constituent Assembly. It was the wisdom of the Constituent Assembly, no doubt. There were eminent leaders and thinkers and intellectuals, but the effectiveness of translating that constitutional morality of that section of people who were indirectly elected based on restricted franchise, how it can be magnified as the morality of India is doubtful. That is one of the problems which India is facing. Many other countries like US or UK or any other Western constitutions who are talking about constitutional morality may not face this kind of a problem, because the body which formed the constitution and the future electors more or less represent the same type of people, same group of people, same social group of people. But in India, what happened, that was a quick transition, because only after the constitution was made, India is going to election with a gap of months, not a year itself. So the election, actually, the people are participating, and that is a different type of different section of people, or a different composition. The people with the electorate was having a different composition. And then the problem started. But in other countries, anyway, kind of a gradual transition from a restricted franchise to more universal franchise happened. So it was easy for a kind of growth, consolidation, legitimacy of what we call as constitutional morality there. So India is lacking, because India did a plus point by opening the floor for adult franchise as early as possible. Should have been done earlier. That is what Jayaprakash Narayan and others were saying, because we were anyway waiting for 200 years for independence, so wait for 5 years to conduct an adult franchise, to conduct an enumeration and go for an election to Constituent Assembly based on adult franchise. That was a demand of the socialists and communists. That's why they didn't participate in the election. And there also, because restricted franchise would not help them to gain any vote, because the voting right was based on income. Voting right was on the basis of education. This type of a restricted franchise, anyway, the socialists and communists had no scope to get a candidate to win in the election. Maybe socialists maybe, but communists may not have any chance. Only one communist member was in the assembly, who was also joined the assembly before partition, Sujit Lahiri. After that, he also was not part of the Constituent Assembly. So what I said, this type of a problem actually about whether the assembly based on an adult franchise or universal adult franchise or a restricted franchise, this actually is becoming a technical issue, but more serious than what we consider it as, to create a kind of acceptance or legitimacy of what we talk about constitutional morality in India as the wisdom of the Constituent Assembly. This was seldom a problem for US and UK, that I said already. And second issue is actually the Constituent Assembly. Generally, we understand that this is a microcosm of the nation, as Granville Austin and others taught us, and our teachers repeatedly taught us. But anyway, there is a kind of a struggle between social classes and groups, or iniquitous relations of power in society, and its own reflection in the assembly debates. We can see if we go through the Constituent Assembly debates. So Constituent Assembly's wisdom shall be understood critically by understanding the divisions in the social relations of power. We cannot keep in camera, because all these things we cannot keep in camera in understanding the origin and evolution of Indian Constitution. We will have to look at it. We cannot hide it. That is why there is a tendency for not only the Constituent Assembly's leaders, also for the Congress for a long time, to hide the differences and highlight the consensus. Anyway, now we are looking at it 75 years back, what happened, and we will have to look at it in a bare form. We cannot hide it because various types of social relations of power and also various social groups represented in the assembly unevenly. And many of the ideological groups were not represented in the assembly. And that is one of the problems that actually when we speak about constitutional morality as enshrined in the wisdom of Constituent Assembly is facing. So here we shall look at the what the commission, because how the social forces and factors, different levels of power they were, and how they were represented in the assembly, and how their interest was articulated in the assembly in the form of certain ideals. If you look at what the constitution has written, you can understand easily, because what actually the will of the assembly, but what they omitted also shows the will of the assembly. That is why we'll have to look into omission and commission of the Constituent Assembly in the form of a text we got as in the form of constitution to understand actually the social relations of power behind them, means the iniquitous social relation of power behind them. And post-independent assembly, and then we will have to look at the history of assembly. The history of assembly can be broadly divided into two: before the partition and after the partition. So after the partition and before the partition, they met. But there is a significant difference in the voice of the general consensus of the Constituent Assembly before partition and after partition. That is also a historical fact. Earlier, anyway, there was a kind of acceptance of two issues, or one issue anyway: separate electorate and political representation by representing, an effort to represent the social pluralism in India perfectly in the electoral representation. There was an agreement of a kind of a separate electorate. Separate electorate is a kind of separate electorate we always consider as, we means the nationalists always consider as a divisive tendency. But generally, this is one of the best form of better accommodation of social pluralism in political echelons. So this type of a separate electorate was not a major issue in post-partition days. It is considered as outdated. And another issue is about the devolution of power, from vertical devolution of power. And this was also, these two were actually the demands of the Muslim League, mainly. Ambedkar's organization also raised the demand, but it was raised. But the first one, Congress agreed. The second one, Congress didn't agree. International Congress didn't agree for a kind of making India as a confederation. That is the two things, two ways in which actually there was a consensus existed, or a consensus was actually, people were cherishing a consensus or seeking for a consensus in the pre-partition period, in the form of polity we want to make and form of constitution we want to get. But these two were diluted. And later on, we are talking about a kind of Constituent Assembly, which actually gave India, the India of the present time after partition, a constitution. And there actually we see the reflection of the assembly or will of the assembly. The will of the assembly means undivided India's undivided assembly's will is not reflecting, but divided India's divided assembly's will is reflecting as the will of the assembly, and as it is reflected in our constitution. And there were also a lot of problems about membership in the assembly. Majority of the members were from, means a major representation in number as well as in leadership role for the people from British Indian provinces, and lesser role for members of the princely states. No effective representation of organization of workers and peasants and many other tribes also were not effectively represented in the assembly. So this type of lack of representation, lack of claiming a representation through adult franchise, all these things were actually affecting the credibility of Constituent Assembly to come with a principle of constitutional morality, technically. And second, and another one, if you interpret the constitutional morality as an ensemble of values, ideologies, etc., what after reading the Constituent Assembly debate, only one thing which actually binds this body of assembly members from different social groups and background is actually one demand. That is actually unity and integrity of India. Unity and integrity of India. Whenever the division of vote is taking place, or whenever division of opinion leads to polarized debates in the assembly, the chief of the assembly, or the chiefs of the assembly, the chief members of the assembly or leaders of the assembly, they're actually coming with one discipline tool. Is it for unity and integrity of India? So unity and integrity of India, if they talk about, everybody else should be silenced. This is the way in which most of the Constituent Assembly debates on several crucial issues, ranging from conversion, ranging to secularism, and many other, and also about federalism and all. All these matters were actually, we have seen that the polarized debates were silenced by invoking the necessity of unity and integrity of India. And that's why the problem is here, because this constitutional morality was invented at a time, or was evolving at a time, by making the necessity of a state. By making the necessity of a state. And also, what I want to say here, the code of conduct and opinion differences, all other polarizations, were all streamlined by showing the necessity of this unity and integrity and necessity of a strong state. No Indian in the Constituent Assembly wanted a weak state. Everybody wanted a strong state. If anybody wanted a weak state, that would be pointed out. Then he doesn't want to, or she doesn't want to support weakening the state. So strengthening the state was actually the inspiration for framing a constitution. And other things, anyway, we can say that respecting the rights and all, it's fine, because if you look at the rights, anyway, as Sujit Lahiri, the lone member of CPA of the Assembly, once said, Constituent Assembly is looking at the fundamental rights from the point of view of a police constable. If a police constable is framing the rights of the people, that is the way in which rights are written in the Assembly, written in the Constitution. It's true, because right with restriction is actually the language. In that context, actually, we are a little bit confused about why the constitutional morality, in the name of that, again, some additional restraints and restrictions on citizens' behavior. This is a question. Besides, some other factors frame the moral consciousness of the Assembly, that I said about necessity of a strong state, unity and integrity of India. They never used the nation as the way in which we hear the frightful term as it is today. Earlier, they were not using nation as such, but state they used in a sense. And also, they were only aiming at creating a state rather than building a nation. And some kind of nationalism, national sense of pride, because we already know that the British already challenged Indians, if possible, come with, if you are able, you come with a constitution satisfying the diverse sections of the society. So all these things were considered as affecting the national pride. So this national pride, and also Congress was also always saying that there is an urgent necessity of transfer of power. Anyway, the issue is that the Congress was actually delaying the transfer of power, and the agitations were actually moving from gradual to gradual type of a way. But after 1940s, anyway, because of some other issues, some other factors, anyway, that we can discuss later, Congress was also saying that a sudden transfer of power is necessary. So anyway, we should create a constitution without wasting time. This is anyway important. And all these things were actually coming out. And also the triumvirate that the Austin is saying about behind making the constitution. One is Constituent Assembly, sure. Second is Congress Party, and third is interim government. What we want to know here is that India made a constitution not before creating a state. There was a state, or there was a proto-independent state, interim government, and other things. That is why the state, the hardware of the state was available at the time when India was making constitution. This is not a kind of a social contract to be signed between isolated individuals coming together and making a state and constitution, but state was already there. And then the constitution was made. So the concern of the state was well reflected in the constitution. That is the issue. Concern of the state was well reflected in the constitution, and all types of moral, constitutional morality or the principles were actually taking into consideration the needs of the state. So what I want to argue here is that we had a concept of state-centered constitutional morality from the beginning, and that was next only considered the citizen-centered. So initially, the constitutional morality of India and the way in which the constitutional provisions were stated, mostly they are about the necessity of state, in a sense, the requirement of the state. So state-centered beginning of constitutional morality and its interpretation started in India from the beginning itself. And as I said earlier, the transformation of the Constituent Assembly from pre-independent period to post-independent period, two cardinal ideas or cardinal principles which would keep a limited government was thrown into air. One is plural social representation. Second is vertical devolution of power in the form of confederation. Congress was ready to agree with the social pluralism and representation, separate electorate, etc. And also the majority community of the time was also feeling they were a minority in many of the provinces at that time. And then there was a consensus about the necessity of a separate electorate for minority and all. But after the partition, that was not necessary for the majority community. So they given up. And next one was very important. So Congress was anyway ready to agree with earlier. But when we are entering into the post-partition period, the Constituent Assembly never was in favor of that, and also the vertical devolution of power. Muslim League was demanding for a confederation rather than a federation, going for a loose federation of India if they want to stay with India. And the International Congress was afraid of it. There may be reasons or apprehensions, I'm not sure. But anyway, this was a kind of an equal weight for the two dominant community, or minority and majority community. That is why the institutional features on which a new consensus was emerging was also for creating a strong state rather than a weak state. So strong state was actually there as a baggage of our discussion, or Constituent Assembly's discussion on constitutional morality. And then the question is about whether the constitutional morality is about citizen or state. Constitutional morality may be partially applied to the state, the power wielders. For example, Ambedkar also says that if the state is acting constitutionally, the citizens are bound to obey it. That means indirectly, as someone else in the Western philosophy, the contract theory said that if the state is not acting constitutionally, you can rebel indirectly. So Ambedkar is bringing a kind of a balance between this application of the constitutional morality to state and citizens. But most of the time, anyway, the constitutional morality became a kind of a pedagogic tool to educate the uneducated masses, rather than the other way around. That is why from the beginning onwards, this constitutional morality, in spite of attempts by Ambedkar and others, had a kind of an elitist base. And remember that the Constitution has put some restraints on state already. If you read at the fundamental rights, anyway, most of the rights were considered as state shall not do, means restrictions on the power of the state. But somewhere, anyway, it never says about any potential violator of right. Just it says that every person is entitled to so and so, like right to religion. There, anyway, the Constitution never says who is a potential violator, but we will have to look at it case by case. A society may be the violator, or the larger religious group is the violator of the individual right to freedom of practice, propagate, etc. So most occasion, anyway, the Constitution, more than constitutional morality, the rights are coming as an effective restraint on the state power. And somewhere the rights are not defined, anticipating the potential violator. And there all the controversies are going on now. And one right, anyway, we can say that one right may be considered as subordinate to the other right, only one right. That is the right to religion. For example, right to religion, as it is in the Article 25(1), can be read as subject to public order, morality and health, and to the other provisions of this part. I mean it by all other fundamental rights. Other provisions of this part, P is capital also. All persons are equally entitled, means the right to religion is subject to other right. Anyway, I don't know whether this is a popular understanding of the right to religion. Our right to religion is subject to our enjoyment of other right. This is what I read from the Constitution. But this may not be the dominant interpretation of this article in the legal circles. Anyway, the Constitution directly says state as potential violator, but nowhere such an indictment against society is indicated. Because we say that Ambedkar had in mind about a society, the social consciousness, not bound by Constitution, acting as a regressive force. But Constitution never point out society as the problem. Only in some place you can say that some of the articles which were actually unanimously accepted in Constitution, two are there. One is anyway about article on untouchability, abolition of untouchability. And second, I heard that it is also an article on prohibition in fundamental directive principles of state policy. These are the two articles without any dissent opposed. That's true because it comes. So then generally there also Society is not pointing out us because there nothing in the article says that the no upper caste should practice untouchability or the practice of untouchability. We know well that upper caste are practicing untouchability. Who else? But it was not mentioned in the constitution. But just a sweeping statement: abolition of untouchability, not only on the basis of caste but on other different grounds. So certain ways in which the society, the constitution wants to fight, it never, it recedes. It keeps away. That's why the constitution is afraid of fighting society directly. Society, in a sense, the dominant social forces directly, but indirectly it does it. And that is one of the way in which actually the constitution making was also going on in India. As Sunil Khilnani was saying, because what the constitution assembly members were doing, the leaders of the assembly were doing, they were actually trying to bring out maximum opinion differences in the assembly. And if they find out that the issue can't be resolved at all, they are doing it, they are postponing or procrastination. Gradualism and procrastination or deferring is actually one of the strategies that our assembly adopted. For example, you take into consideration uniform civil code. It was not implemented, it was postponed. And language, national language or whatever, it was not implemented, official language, and later promote Hindi. Fine. That is a way in which actually, this is a practical via media that the Constituent Assembly was finding out. Likewise, it also didn't want to directly antagonize the dominant social groups at all. That's why the Constitution wanted to prove beyond an immediate objective of criticizing and pointing out a mistake in society. But in state they were doing. State shall not means state shall do, can do. So it should be prevented. Society can also do, but nothing. And another one is actually the silence about the potential violator of right when you are reading about the economic right. Nowhere, no restriction on market is envisaged by the Constitution at all. No restriction on market. So it is leading to, that is why economic rights anyway silent. We know well that political rights, if you look at, there is a rich articulation of political right and a partial articulation of social right, not full. That is why the new social movements are criticizing the constitutional position on several types of their rights. And the third one, like economic rights, silent, nowhere, zero. So this is the way in which, if you consider morality is not an objective in itself, but it has to find out an end. The end of morality is justice. So if you look at the way in which actually the differential preferences or differential way in which the Constitution is emphasizing on the rights, you can see that economic rights zero, social rights partially, political rights in a full-fledged way, but with restriction. Like, remember again what Sujit Lahiri was telling about, Constituent Assembly was making rights means only political rights. Like a policeman is looking at the right. This is the way in which the rights were also formed. And the constitutional morality, now we can look at it, constitutional morality demands us to convert the constitution from a set of procedure and structures to a moral guidelines of action. So we generally call it like, what is constitutional morality? People will start speaking about more abstract concepts like spirit, basic structure, fundamental principles. So getting a clarity about what do they mean by this, no idea. Anyway, in social science, there is a limitation for objective and rigid certain understanding of concepts. But within all that, but constitutionalism, we have some understanding. But this constitutional morality is like that again. All are conflated. All these loose concepts are conflated in what is called as constitutional morality. And that's why I said in the beginning, it is now appearing like a vessel word. In a nutshell, we got a constitution which upholds a high moral relevance to all the liberal political rights, partially to social rights, and only a silence on economic rights. That makes the justice. This is the point which I said just earlier, which is the objective of morality as not very comprehensive as many of us think. The objective of morality, if it is justice, that justice is not very comprehensive as many of us think. It may exist as a promise. It may exist as an aspiration. It may exist as a wish. But the concrete way in which actually what does it give? The question has to be answered, for which a detailed research is required. Means the answer is not very clear from the constitutional provisions. Ability of the constitution to morally determine the power of the state was limited, I told you, because state was actually anticipating a constitution for conducting its affairs for future, rather than a constitution is coming and deciding the character of the state. State was already there, and the state is actually making a suitable way to conduct its affairs. was limited, and it was the dominant idea about the state in the intermediate years in the post-partition period that determined the constitutional principles. So constitutional morality failed to check the power of the state as we need in a very democratic way. But the proto-state was animating a constitution. A proto-state was animating, and the party, which was actually called as Congress at that time. Proto-state was animating a constitution to meet its requirements rather than vice versa. So the constitution was not deciding the state as a whole, but state was deciding the constitution. This is the way in which constitution was made in India, and its problems anyway we can discuss later about more if there are questions about how it becomes a problem in understanding constitutional morality or operation of constitutional morality in India, in working of constitutional morality in India. Second is anyway about working of the constitution. Then we will have to look at one important phase of the Indian polity, and whatever and the way constitutional morality existed with respect to state power evaporated at the time of Congress under Mrs. Gandhi's authoritarianism. I don't call it as fascism. Judiciary came to rescue the constitution from arbitrary use of state power, for example, Kesavananda Bharati case and others. But we have seen how ineffective it was before an executive armed by majority in the parliament. Certain things about cultural, economic issues, without giving a firm opinion, started raising head, demanding a sudden solution. Gradualism, procrastination, as I said, as the Constituent Assembly was doing. But some of these critical issues were brought for a sudden resolution. Secularism was passed as part of secularism was included. More socialist commitment was shown. And also there was a call for Garibi Hadao and a kind of a class populism. Indira Gandhi was doing a kind of a class populism to reorient the constitutional morality to a different way. Gandhi was using mainly internal security as a reason for strengthening the power of the state. She was not much speaking about, I don't think the national security nowadays is constantly invoked to curtail the freedom, rights, etc. But earlier Indira Gandhi was not using the national security as such, but internal security, law and order problem. That is also to protect the interest of the state and those who wield the power of the state. But still it was not colored in a very national way, but anyway, internal security threats and class populism. And Gandhi, anyway, we know well that Indira Gandhi was enjoying the rights and privilege of violating constitutional provision, at least in 1 or 2 elections. But later on, when the actions were affecting the lives of the people more directly due to emergency, she was punished. But we cannot say that that punishment was actually a kind of a reaction of people for protecting the constitution, because in the other elections we never see the people of India standing together to guard the constitution. Never it happened. And also we can interpret and we can say that in a third world country anyway people reacted against emergency. That was also a big sign of good democracy in India. Fine, keep our relief there, but anyway it never repeated in any other elections. Punishing a government for violation of constitution was not at all happening. And phase 3, we can say that a kind of a brief phase. This is not purely political. This is a brief phase which started in 1980s. And in the 1980s, we see a kind of a series of intellectual attack on the fundamental principles of constitution. One important fundamental principle, which one of the important, fundamental principles which was attacked by the intellectuals during the period is nothing but secularism. Anti-secular manifesto by Madan and others were published. Anyway, I don't say that whether they can criticize or not. There is enough room for an intellectual argument against secularism. But secularism lost its academic credibility, began to lose. I don't know what happened in Kerala, but I'm talking about other institutions. In 1980s itself, this type of a voice against secularism came up. And this is considered as one of the moral principle of Indian constitution. Am I right? If you go by Kesavananda Bharati principles, etc., and most of the speakers. But this one doesn't enjoy any kind of an intellectual support as it was earlier. So legal and institutional consciousness was divided about what is the constitutional morality, and principles of constitution and concept of morality was also challenged. The concept of morality itself was becoming much diverse than it was before. And judiciary affirmed its faith on secularism, but intellectuals and a new variety of identity-based social movements dissociated from the modern notion of secularism and appeared as its critics. Not the fundamentalists BJP I am talking about. The CM, the constitutional morality as a code of conduct, the second interpretation of that. That was also moving to a kind of a falling down. And 1980s, we know the way in which parliaments were disrupted, political violence and other things. And middle class became depoliticized. In such a context, constitutional morality, anyway, what was that during 1980s? Anyway, we can search and find out. And next phase is phase 4. That anyway refer to what is the current phase. Continuation of the debacle of constitutional morality with respect to exercise of power, state power, and as a shift in its meaning by bringing nation and nationalism. Because earlier I told you constitutional morality was defined vis-a-vis state power. Now state power is used less, and instead of state, we are hearing more and more about a kind of another very frightening term like nation. Frightening term in a sense because of the ferocious way in which it is invoked in the minds of people of India today. With a punishment, because if you don't follow, there is a punishment. That is the way in which I said nation is frightening today. Bringing nation and nationalism into our focus, and also a majoritarian cultural nationalism under BJP is coming up, and cultural populism they are using. But we know well, and I would limit my discussion, my lecture by 2-3 minutes maximum. Cultural populism they are using, and as I mentioned earlier, sometimes to counterweigh some of the basic notion of constitutional morality, Indira Gandhi was actually acting against constitutional principles, but bringing a class populism. Here what happens, a cultural populism, but Indira Gandhi was fortunate to have a developmental state or planned economy state of the old mode in her disposal to bring out a kind of class populism. But this present government anyway is facing a problem from this open market economy. They can't do it like that. That is why they are mainly depending on cultural populism. Otherwise, if they were going by the class populism, they would have agreed with they wouldn't have passed the farmer law, anti-farmer law, or whatever the farm laws. But they did it. Means under the compulsion not of class populism, but under the compulsion of capitalism. So this is anyway the problem that the BJP is facing now. I would elaborate it on later the point. And in this critical juncture, when the constitutional morality is weaker in both aspects, principles, code of conduct, Supreme Court started pronouncing it more frequently. Are we moving beyond and gaining more if we are using constitutional morality than the Supreme Court said about principles, basic structure in 1970s? I'm not sure. What is the nation? What is going to be the verifier of constitutional movement? That is what I want to say here, because nowadays what happens, there is a kind of a thing is coming up like nation, which is going to be the verifier of constitutional morality, not the state. Earlier, the state was actually verifying what is constitutional morality. The state was considered as important to keep in mind to design a constitutional morality. Now, nation is appearing as verifier of the constitutional morality. And that's why I say, because if we don't use the constitutional morality carefully now, I think there is an all wherewithal in the constitution to be to the parivar to use it as their favor, a kind of a constitutional morality. Beware of one article I would like to mention, one book also by Preetham Singh about the Hindu basis of Indian Constitution. That would give much and more for the parivar sometimes to use this constitutional morality by bringing in the nation and use it in their favor. Here also the same tragedy. First time anyway it happened, tragedy of constitutional morality by bringing the state and defining constitutional morality. State started defining. Now nation is trying to define constitutional morality rather than other way around. This is the issue that we are facing now. Two vulnerabilities of the concept I'll tell you. One is actually more subjective. That is very easy for anybody to interpret it the way in which they want. And second is a kind of a social elitism of the liberal intelligentsia. These are the two problems which the concept is facing. I'm not telling about abandoning the concept or fighting against the concept. These are the two drawbacks of using the concept to rejuvenate Indian democracy and constitution. And we know well that court is speaking and coming. How many court verdicts? Because if you take into consideration 1,000 court verdicts, only 1 or 2 may be standing with constitutional morality and 900 are standing with social morality. So where the court is going to rescue the concept, I'm not sure about it. If you go by, I am not talking about Supreme Court judgment alone, because various court judgments, everyday pronouncement, if you take into consideration the morality there, how many of them are expressing constitutional morality? So we cannot depend on one or two judges. As such, I am telling you, because judiciary as an institution is also not a guardian of. Some judges are coming up. So we will have to wait for the next judge to come, an enlightened judge to pronounce constitutional morality, not the judiciary as a whole. There is no proof. I'm not talking against judiciary. I'm just saying about there is no proof to say that based on a quantitative classification of judgments on morality, classify them constitutional and social. How many of them are constitutional moralities pronouncements? Only very few. And another issue is about public consciousness, about the utility of this concept, constitutional morality, and in the popular common sense. We are talking about morality, constitutional morality, and all. Finally, the people are asking a question: what the Constitution gave to us? An unemployed. Before an unemployed, if I am talking about constitutional morality, he needs a job, he needs a means of life, he needs a livelihood. Then I am talking about constitutional morality. This is another problem that I told you, because many things the Constitution has done to give some room for talking about its constitutional morality freely to the people who are needy. But certain things the Constitution didn't do. So how to express this constitutional morality to a person who is actually in need of certain types of rights to meet the life? This is the issue. So apart from the charity to the poor, there are directive principles. Accept untouchability, concessional treatment to minorities and backward castes. On the labor front, agrarian relations, the Constitution's role as a giving something, means a giver, is limited. It may be an arbiter, it may be a kind of a monitor. It is not giving. That giving is very important. And that is anyway Indian Constitution sometimes already. This is an old criticism, not a new criticism. But this one is also becoming a problem. If the Constitution doesn't give us some material, tangible things and commanding, and people only it demands. Constitution demands from the people high level of moralism. But what it gives, the question anyway, the Constitution has to confront even in its 75 years. Anyway, Constitution protects our life from external aggression to, anyway, without Constitution also the ruler will protect us. What else? This is the question. And also some kind of fundamental framework and certain types of legal remedies we are getting, all are fine. But what I am ending my discussion, my lecture today, now, with one dimension of study will actually help us to understand it more. That is actually about the Constitution in everyday life. We have known, anyway, much of the literature about Constitution in political science discipline is about what are the legal cases, what is the history, and what is the institution law combination. So institutional studies are there, historical studies are there, and also the pure constitutional philosophical studies are there. But very less has been written and researched on the working of Constitution in an everyday life, people's understanding of Constitution. This is one of the area where anyway those who are more interested can do research in future, and some research has come out. I'll tell you about one scholar who has written from Princeton University about Rohit Day, People's Constitution, Everyday Life of Law in Indian Republic. That is the way. Then only we can understand what actually is a constitutional morality in the popular common sense. So the popular common sense, if you miss, and we are telling certain legal sermons to people about constitutional morality, nobody will take it into consideration. And the necessity is that we should also understand, the academicians must understand what actually the people have in mind when they think about Constitution. Means an everyday life of Indian Constitution or Constitution in everyday life. And for other critical reading of the background of the constitutional morality or principles, constitution making, etc., one of the best that I would suggest is Shobhanlal Dattagupta's Justice and Political Order in India. That was published in 1979. The other book I told you about, 2018. With these two references that I am just pointing out to bring out a conclusion for what I consider as an interaction with you, not a lecture. Thank you.